Hey, I'm Paul Rabelais, and in this video we're going to talk about how to deal from an estate planning perspective with a family member who either has or shows signs of dementia. All right, so these days people are living a lot longer. The healthcare industry is doing some amazing things, allowing our bodies to live a lot longer than we used to. But as a result of people physically living longer, you see a lot of people who develop those mental conditions, Alzheimer's, dementia, as some of my clients say, old timers, and where they get to a point where they no longer have the capacity to understand, things that they need to do. So that plays a significant role in the whole estate planning process. And I'm going to identify several issues that really need to be addressed when a family member either shows signs or has dementia. So let me give you an example. Let's say we have maybe a couple with two children, and I'll call the wife, I'll call her, and I like to come up with these names that are fairly easy to remember in my examples. I'm going to call her Dementia Diane, and she's married to overworked Oscar. And I call him overworked Oscar because if Dementia Diane has dementia, guess who's stuck doing all of the housework? And guess who's stuck watching over Diane, keeping an eye on her, and he is going to be overworked as the caretaker and house maintainer and all of that stuff that Oscar has to do. They have two children. We'll call them thing one and thing two. All right. So my first point of emphasis is, as soon as there is a sign that dementia or mental capacity may be diminishing, and that's usually when families tell me, our mother or my wife seems like she's forgetting more things than she used to forget. You may be able to have a conversation with her and you would have no idea that she's forgetful, but we know because we're around her all day, every day, she seems to be forgetting things that she used to remember. So I would say, at the first sign that there may be trouble, you need to act immediately, because those conditions typically don't get better, they progress, they worsen. And so important to put, oftentimes to put estate planning, legal programs into place while Dementia Diane has the capacity to generally understand, the things that she's doing. So the no-brainers are, make sure Diane's will is in place, make sure her powers of attorney are in place, her living will. And real important perhaps to, once she signs those powers of attorney, maybe she appoints her husband, overworked Oscar, as her agent. Maybe she appoints one or both of the children as the alternate agent or agents. And since we know her condition is going to worsen, if Dementia Diane has an IRA at a financial institution, what's probably a really smart idea is, once Diane signs her power of attorney, take it to the financial institution and say, look, Diane's starting to get forgetful. We may have to use this power of attorney that Diane signed, years from now. Are we going to have any problems with this power of attorney that Diane signed? And maybe they'll have their attorney team look at it. Maybe they'll say, well, we'd really prefer that Diane sign our financial institution's power of attorney form, and so you got to get that done. So taking it to places where you may need to use it is really not a bad idea. All right. And while Diane is getting her legal affairs in order, Oscar ought to be getting his affairs in order. And as Oscar is getting his affairs in order, he shouldn't appoint Diane to any kind of position of authority, not having power of attorney for Oscar, not being the executor of Oscar's will. In general, we want to set things up so that Diane never has to sign anything or have any responsibility to get anything done ever again. Okay, so the next thing that you may want to consider with Diane and Oscar, if she still has the capacity to generally understand, the nature and consequences of what she's doing, is perhaps forming a living trust. And the purpose of that is to arrange what Diane and Oscar own so that Oscar can handle all of that for the rest of his life by himself. So it may be a living trust where Oscar is the sole trustee. And then if Oscar can't be the trustee, maybe, thing one and thing two could be the successor co-trustees. But Diane would never be a trustee of that living trust because, we just want to arrange it where she doesn't have to make any decisions. So that's another thing to seriously consider. Another thing to seriously consider, and this will depend on, what that couple's net worth is. If they do have, several $million, then paying for Dementia Diane's long-term care may not be an issue because they have the funds to do it with their millions and millions of dollars. But if Diane and Oscar are kind of like, middle-class people who may have saved up several $100,000, while they were working, anywhere from a few to several $100,000, then at this point, we have to realize the possibility that Diane, with her dementia, Alzheimer's, whatever it is, whatever it might be in the future, we have to realize that it's more likely that Diane's going to need long-term skilled care, perhaps in a nursing facility, because that's just, when the mind goes, that's one of those conditions that renders it more likely that someone would need long-term care. So on that note, we want to make sure that that Dementia Diane never either inherits anything or never is the beneficiary of an account, because if Diane inherits in the future, then that's going to cause assets to be added to her estate that would have to be, just completely, spent down until there was less than $2,000 before she would qualify for long-term care Medicaid in a nursing home facility. Because the problem is Oscar's taking care of her for now, and he's going to keep taking care of her as long as he can. But if Oscar happens to pass away before Diane, and that's a possibility. Oscar could get worn out, and Diane, while her mind is not good, physically she could be, strong as an ox. So if Oscar dies, we want to make sure Oscar's IRAs, for example, it's traditional for the husband to have an IRA and name his wife as the beneficiary. But if it's that way and Oscar dies, now Diane's got to do a bunch of paperwork to get it in her name, and even worse, she'll have to deplete it all if after Oscar, her caretaker, dies, she's got to go into a nursing home. She'll have to spend down all of what was formerly Oscar's IRA. So maybe with Oscar's IRA, what he does is he names thing one and thing two as his beneficiaries. And the family has an understanding that if Oscar dies first and those IRAs go to thing one and thing two, they're going to set that money aside. Sure, there's some income tax consequences, but other than that, they're going to set that money aside and use it for Dementia Diane's needs. But those funds that were in overworked Oscar's IRA, they won't penalize Diane from being eligible for long-term care Medicaid. Same thing when we're doing Diane's will, we need to do Oscar's will, and if Diane's potential nursing home care needs to be considered, then Oscar in his will or in his trust doesn't want to leave anything to Diane, because again, that just lumps assets into her estate. Again, maybe there's the informal family understanding that if Oscar dies first, things go to the children will set it aside, and then Diane will be able to qualify for long-term Medicaid if that is necessary, and thing one and thing two can use the assets for additional needs, sitters and other needs that Dementia Diane might have. Okay, so another point, maybe just a couple more points. Another point that I want to make is, and this is just because I'm an attorney, and if you wait too long, you're likely to put your attorney who's trying to help you in a difficult position of having to notarize documents when Diane doesn't have the capacity to understand what she's doing. I'm just going to ask you as a favor, don't put the attorney in that position. I've had to tell people when they came in, and if that demented person had capacity, there were some things that we really could have done to help protect, what the family had saved. And I just had to tell them, I'm sorry, I can't notarize his or her signature because they don't have the capacity to understand what they're doing. And so really acting immediately is really critical when you start to see signs of, dementia or Alzheimer's or, whatever that mental condition might be. So I'm just asking you a favor, don't put the attorney, in that position. Okay, so that's the planning for if you do act appropriately and you act immediately as soon as you see signs, while the person still has the general capability of understanding what they're doing. Now, sometimes families wait, conditions progress, procrastination, busy, don't think about it, and then they, when it's too late, then they come to me or somebody like me for help, and it's too late. Dementia Diane, she doesn't have the capacity to understand what she's doing. And so that opportunity to change Diane's will, have her do a power of attorney, structure assets in a way that they may be better protected if there's a nursing home situation, that opportunity is usually lost. But still, sometimes if Dementia Diane is really, she has no more capacity to understand what she's doing, then sometimes we have to do what we call in Louisiana, interdict Diane. Or in other states, we call it go through a guardianship proceeding. And those are really, really difficult, and they're just a mess. So our procedure, let me give an example. Let's say Dementia Diane and overworked Oscar, their home needs to be sold because they need to move into an assisted living facility or for some reason their home needs to be sold. And Diane, they never did any estate legal work. And Diane never signed a power of attorney. And now Diane is demented to the point where she doesn't have the capacity to understand what she's doing, but the house has to be sold. And to sell the house, they need the signatures of both Oscar and Diane to sell that house. Well, Diane can't do it. She doesn't understand what she's doing. So the family then has to sue Diane in what we call one of these interdiction or guardianship proceedings. And our state's procedure in Louisiana is we sue Diane. We have the sheriff serve papers on Diane. Diane has to have a lawyer. She's not going to go get one because she doesn't have the capacity to. So we have to wait several weeks for her not to respond to the lawsuit. And then we have to get a judge to appoint a court-appointed attorney for Diane, who has to visit Diane and check with her doctors. And then there's court hearings set for the family to go to. So a judge can hear all of this evidence on whether he should take Diane's capacity to transact for herself away from her. And if the judge does that, then the judge has to determine who should be her guardian, or in Louisiana we call it who should be her curator to be able to transact for her. And that proceeding takes many, many months, so the home just sits there kind of idle. And then the home perhaps gets sold by Oscar and the guardian later on. So just a lot of stuff, and once they've gotten to the point where they need to be interdicted, then the opportunity to reposition assets is often gone because that curator or that guardian, has to take action that is, solely in the best interest of Dementia Diane versus what's in the best interest of the overall family. Okay, so my hard conclusion here, and before I give you my final advice, I want to make sure you smash the subscribe button and then hit the notification bell so you don't miss anything. Also, thumbs up would be great. Constructive comments below are always awesome. Feel free to share with others who may have a similar situation. But my point of emphasis here is, I know some people with estate planning, they procrastinate. It's kind of, we don't want to face it. We don't want to talk about it. But here's an area you got to overcome any procrastination that you might have and act immediately when you suspect that there may be coming some gradual progression of a loss of capacity. And get things in order. A lot of things here that need to be discussed with the family, and a lot of action that may need to be taken that the traditional family doesn't necessarily take, but this is a unique situation that requires some, some unique action. Okay, hope that helps. 10 a.m. every morning Central Time, new educational estate planning video will be published. We'll see you tomorrow. Have a great day.